for it.
Good afternoon, Mike. How are you?
Good afternoon. I'm doing well. Seems like a nice day, a little breezy. And how is it where you're at?
Doing good. It's actually some sunlight. There's no rain, so looking good, feeling good.
Glad to hear it.
All right,
Please
I'm going to give it a couple of
introduce-
seconds.
Yep.
Oh, go ahead, Mike.
No, please introduce everybody to why we're here, what we're doing.
Awesome. I'll do it really quickly. Everyone, you'll have to excuse me. Having some technical difficulties this afternoon, but I'm going to give you a quick intro and then kick it over to Mike. He's got a really cool presentation for you all today. I think you guys will enjoy. Lauren Simpson. I am with the SBDC, or the Small Business Development Center. We're a national program with over 1,000 locations across the country.
Lauren?
Now, our services are at no cost to you.
Lauren, you're
Mike, can you
cutting
hear me
out.
okay?
You're cutting out. So why don't you, do you have the presentation? Okay, so I apologize. Lauren has been cutting out, so I'll go ahead and go forward with the introduction. We are part of the Los Angeles Area Small Business Development Center. There are 1,000 centers across the nation. We are funded by a grant from the Small Business Administration, a grant from the state of California. We're supported by colleges, universities, and other partners throughout the nation. This is a no-cost service to you, paid for by those grants. We provide one-on-one consulting to business owners. We focus on small businesses, keeping in mind that the SBA defines small businesses as those with 500 employees or less in most cases. So we work with people to help them start businesses, grow businesses, expand businesses. We have consultants, colleagues of mine and Lauren's, who are experts in many, many different areas. And we are here to help you. That's our purpose in life. It's an economic development program paid for by your taxpayer dollars. There's approximately 200 consultants in the LA region. I think we have 8 centers scattered throughout LA County. We also do numerous workshops, and we help people gain money through access to capital programs like the grant that Lauren might talk about. We also work with the SBA and SBA partners to help you get capital through loans. We also help with marketing. Basically, any type of business concern that you have, other than possibly your own direct operations, we can help with. Think of us as a management consulting group. Lauren, you want to add anything to what I just said? Lauren is muted. So thank you for joining me today. Typically, we have somebody named GB join us. GB is in the middle of tax season. He's a CPA. He'll be back next week. So I'm here to go ahead and do a presentation, and I'm going to be talking about intellectual property. Now, before I go forward with that presentation, although I do have a law degree and 2 finance degrees, I am not an attorney. I worked in private industry, and I am not an intellectual property attorney. However, I will go through the basics. So with that in mind, I'm going to share my screen. Please keep in mind a couple of rules here. Put your questions in the Q&A. I'll answer them as best I can. If it's not related to the topic matter, I'm going to refer you to Lauren or someone else to help to make an appointment with one of our other advisors. We have an hour together, and I want to stay focused on the topic. Please put the put the questions into the Q&A, not into the chat room. The chat room, Lauren will put in various links that might be useful to you. For example, right now, Lauren, if you could go find the U.S. Patent and Trademark Office link, that would be helpful. And I also want to mention that there's something called the LA County Economic Opportunity Grant that you should be aware of. Lauren and her colleagues are offering workshops every day of the week. And Lauren, if you could please put those links into the chat room. I think everyone in LA County that was in existence as of 2019 or sometime in 2019 is eligible to apply for the grant. So you might as well go for it. All right, so with that in mind, I'm going to go ahead and go forward with this presentation. I've been an advisor with the SBDC since 2016. I have my own consulting firm because this is not the only thing I do. I'm also a resource for CMTC, which is a California Manufacturing Technology Corporation. It's a nonprofit. I have, as mentioned, two various degrees. I have a deep and broad understanding of many business topics. And although you see me on the screen and maybe some other folks on the screen when you go to these workshops, remember, we have lots of folks who are senior level expertise in many different areas to take advantage of it. So we're going to be going into intellectual property. There are intellectual property laws that you should or might already be aware of that protects the rights of creators and innovators by giving them exclusive ownership of their creations. So there are three main types of IP protection: copyrights, trademarks, and patents. And then there's a trade secrets. And basically, you do not file anything for trade secrets because you're not letting that information out to the public. Oftentimes when people say they're going to file a patent, I remind them, that's great, that's wonderful, it's an expensive process. Oh, and by the way, that means you're telling the world, including people in China and India, how to do something. So perhaps you might not want to file a patent because how are you going to enforce your patent in China? Even if you get a global patent, you still may not be able to afford it. So perhaps you might want to keep it a trade secret. So just keep that point in mind. I'm going to go forward here from this slide. So again, copyright is the protection of an original work that you have produced on your own, which gets to be interesting because now we have ChatGPT, and I use ChatGPT to help create this presentation. Trademarks, they are words attached to accompany goods or services. Do not confuse trademarks or service marks. That happens all the time. There are two different types of marks. Service marks attached to a company's goods or services. Okay, they're images, they're not words. And then patents are inventions. And then there's trade secrets, and trade secrets are formulas, practices, processes, designs, instruments, patterns, and so on. It's confidential information is what it is, relating to the way you do certain things. I worked for a company that had a specialized process for holographic imaging, and it didn't file a patent. And as a matter of fact, as the CFO, I wasn't even allowed into the back room where the process was handled because it was secret. And they only wanted people that were working in that specific area in that back room. There was no photos of it. It was never published. Only people there, and they were sworn to secrecy. That was a trade secret. And it still exists, by the way. So, copyright provides a legal right. Keep that in mind. It is a legal right. It's something that you can act upon if you handle it properly. And it gives, and it's related to original works. You're not copying somebody else's work, which is weird, which is really interesting because when you get to ChatGPT, are they your words or is it the AI's words? Something that this report will eventually, I think, have to handle. So it's an original work with the exclusive right to use and distribute that work. And that includes books, music, movies, artwork. But if you think about beautiful AR and other AI software platforms out there, image to text converters, I'm sorry, text to image converters, is that your artwork? I don't know the answer to that question. That's something that the legal system will have to work out. So copyrights are valid for the lifetime of the creator plus a certain number of years. However, there's the Mickey Mouse rule, which I'll explain later, which really threw a wrench into this. So copyrights give creators the exclusive right to reproduce, distribute, display, create derivative works based upon the original creation. So you go ahead and write a book. Now you're going to write a screenplay. Now you own the rights to the book. You own the rights to the screenplay. And now you're going to create imagery based upon that work, yours. Now, registration is not necessary to establish copyright protection. However, you won't be able to force your rights. So there's a law that came out, a Supreme Court decision that came out that said in 2019 that in order to enforce your rights, you must now register your copyright, mandatory, so that you can protect your work. So what's the benefits? You can bring an infringement action, okay? It enables you to file a lawsuit to enforce copyright in federal court. Remember, this is a federal rule. The Constitution was ratified in 1788. It was drafted in 1787. And before that, we had the Articles of Confederation. But when the Constitution was ratified, New York State was the last state to ratify it. It gave Congress the power to regulate creative works, not the states. Before we had the Constitution, the states had their own rules. And when we became the United States, the federal government took certain powers, like the ability to contract alliances, for example, and the states reserved some powers. So it is the federal government. Now, that doesn't mean the states don't have copyright trademark laws. They do. You can actually file a trademark in the state of California. You don't have to necessarily file it with the federal government, but if you file in the state of California, it's only good in the state of California. So with regards to copyright, this is federal law, okay? And you must file an application for registration before you can sue someone for infringing on your copyright, even if the infringement has already occurred. That's mandatory, okay? It doesn't cost a lot, by the way, to file these copyrights, $60, $70, something like that. It provides evidence that your copyright is valid. And so you want to have proof that you created that work. And how do you do it? You register it. And it shows that you have validity in regards to that work. It enables you to claim statutory damages and attorney's fees. And it creates a public record. It puts others on notice that your work is protected by copyright. Because how is somebody supposed to know that if you haven't registered it, right? Once it's registered, it becomes available as a searchable item, and people can find out that, hey, yes, you are the owner of that copyright. So there's a lot of benefits to go ahead and registering copyright. It's easy to do. It doesn't cost a lot of money, okay? So the Copyright Act requires the copyright owners to deposit 2 copies of their works with the Library of Congress within 3 months. So there's a time frame here after they've been published. This is called the mandatory deposit. And when the applications are submitted to the Copyright Office, this is all handled by the U.S. Patent and Trademark Office, by the way, which in the Copyright Office is part of the USPTO. There's an application that will satisfy the requirements, okay? You must submit the application. And there's different types of applications depending upon what you're doing. Here they are. For literary works, it's the Literary Form TX. For visual works, it's the Visual Form VA. For serials, publication serials, it's the Serials Form. For performing arts, that's a PA form. And for sound recording, it's an SR form. Make sure you file the right form, or else you will not receive your copyright protection. Important to remember that. And all these forms are available at the U.S. Patent and Trademark Office. So if you do a Google search for copyright registration forms, you'll find them. These images were actually taken from the Copyright Office website. So what are the fees? Back in 2020, before 2020, it was $35 for a single author, same claimant, one work not for hire. They raised it in March of 2020 to $45 for a single work. For paper filing forms, it's $125 now. You can see down the list here what they're charging. So the actual fees to register for a copyright are not all that expensive, and it's well worth doing to preserve your legal rights. Let me continue on. Now, this is interesting because Mickey Mouse first came out under this Steamboat Willie, which was a cartoon. And it was scheduled to come into the public domain a number of years ago. But Disney pushed to change the laws such that they gain additional protection from Mickey Mouse coming into the public domain. So the Sonny Bono Copyright Term Extension Act was passed in 1998. And now Mickey Mouse will come into the public domain in 2024. But anyone coming close to using the trademark or the copyright of the more modern version of Mickey Mouse will be shut down instantly. So the 1998 Act extended terms to, the terms for the copyright protection. And it's now the author, the life of the author, plus 70 years, and for works of corporate authorship to 120 years after creation or 95 years after publication, whichever end is earlier. So be aware that of these copyright terms. It's important to know that. So that's copyright. Now we're going to be talking about trademarks and service marks. And by the way, next week, unless GB has another topic, I'll be going into patents because that's more information, more knowledge, and a lot of technical detail. So I'm going to sticking with copyrights, trademarks, and service marks for this presentation. Bear in mind that there's a difference between a trademark and a service mark. Most people get that confused, okay? Plus, there's a distinction between a registered trademark, an unregistered trademark, and an unregistered service trademark. So we're going to go through these distinctions. So a trademark protects a word, a phrase, symbol, design, or combination of those elements that distinguish the goods of one company from those of another. It's related to goods, not services. A service mark is similar to a trademark. Oftentimes people use trademark when they really mean service mark. It's used to protect the name, logo, symbol that distinguishes the services of one company from those of another. So trademarks protect goods, service marks protect services. If you register a trademark when you should have registered a service mark, then you're not going to gain the protections that you want, okay? And now you can put a symbol on your logo, and you can identify it as an unregistered trademark, TM, unregistered trademark. Or you can register an unregistered service mark and put SM. However, just because you do that does not give you any protections. You must actually register your trademark or your service mark with the US Patent and Trademark Office. And then you get to use the little R in the circle here to see with McDonald's, okay? You can see with Starbucks, they use the TM. That's an unregistered trademark. So if your company sells an item or multiple items, you need to trademark the mark used to represent the business. If you have a company that provides a service, focus on the service mark. Using TM in your mark represents trademark, SM represents service mark. They don't hold any legal significance. The only symbol that has legal weight is registered symbol, and you can't use a registered symbol unless you actually register a trademark of a service. And that's done to the US Patent and Trademark Office. So to apply for a trademark, submit an application that describes the mark. And by the way, you should be working with a trademark or a patent attorney to do this type of stuff because it gets technical. And you have to describe the goods or service will be used for and pay the fee. The application is done through the USPTO online site. You can still do it by paper, and you should do a search first at the test system, that's an online system at the USPTO. And I keep hitting on this because most people get this confused. Know the difference between a service mark and a trademark. So Nike has a trademark. It sells apparel and footwear and products. But McDonald's has a service mark because it offers food and restaurant services. Some companies will have a service mark and a trademark, like UPS, because it offers goods and services. You can buy boxes from UPS, but it is also a service provider. So you can have a service mark and a trademark, but apply the service mark appropriately to what you're doing and the trademark appropriately. So why do you want to do this? Well, you don't have any rights against that of your work unless you file a trademark or service mark. If you create a website and you create a logo and you don't register a trademark or service mark, and no one can take it. Doesn't matter. You have no protection. Okay. And it might be important to you to protect that trademark or service mark. When you actually file the paperwork for a trademark or service mark that only contains characters, it should be submitted in all caps. It doesn't matter if it's submitted in all caps, the protection will extend to if you use in lowercase or capital letters, but the actual application should be submitted in all caps. So a trademark or a service mark that contains a design, logo, or symbol shall be submitted in the exact form that you plan to use. Really important. If you make a change to the mark, you have to refile for a new trademark or service mark, and it's more fees. And I know people, we have clients that have done this, try to do it on their own. They don't provide the proper description. They do not appropriately fill out the form. It gets rejected, then they have to do it again, or they go to a trademark attorney or patent attorney. Go to professionals and know what they're doing. Use them, they're there for a reason. This is technical. The description is very technical. By the way, you might want to consider submitting several applications at once. For example, when you submit the design in color, only that exact layout has protection under the laws. So if you change the color, guess what? No protection. If you change the font, no protection. So you might want to consider several applications. If you plan to use a design in another color, or in black and white, or a different font, or a different way of presenting it. So many times folks will present multiple different types of trademarks or service marks. And the USPTO will send you a rejection letter, and they will tell you to go ahead and resubmit it. You also need to do a search ahead of time at the California trademark site and at the US Patent and Trademark Office to be sure no one else is using that trademark or service mark. You might want to do a search on Google as well, or GoDaddy, to be sure that somebody isn't using the logo or the image or the characters, but that does not necessarily give them protections unless they have filed a trademark or a service mark. The California trademark, as I said, or service mark is only good for the state of California. So what could happen? We don't do it, register a trademark or service market. Well, you can't protect your trademark or service mark. Okay. So if someone else has registered an identical similar mark, you lose. It's your responsibility to perform a search and test. It's up to you. No one else, or your attorney or someone that you engage to do that work. Okay. And if you don't file for a trademark or service mark, you could infringe on someone's trademark or service mark if someone else creates a similar mark. Without registering a mark, you don't have any legal rights to it. By the way, it's almost nearly impossible for another person to find out that they're infringing if you haven't registered. You have no claim. I mean, how are they going to find out that you're using it? So if you register your trademark or service mark, it's part of public record, and then people can search for it. So if the other individual chooses to file an application, you lose the option to do so. And it's real difficult to prove that you've been using a mark longer than the other person. That's really hard to do. And now you're talking about spending a lot of money on attorney's fees to protect your mark. Oh, and by the way, you might be hearing my New England accent when I say mark. I'm from the Boston area. So my accent still comes up and I don't even realize it. So I'm saying the word M-E-R-K, mark. Now, there might be reasons not to register, okay? They don't like the way the TM or SM symbols look on the mark. I mean, these superscript or subscript letters might clutter up the text, the layout of your design. But when using any of the symbols in print, you can simply use one in the first sentence of the mark. It reduces the clutter. So there's some aesthetic reasons people may choose not to register a trademark or a service mark. There's also the cost. depending upon the category, I mean, it's expensive, $225 to $600. And if you go do an attorney, it's even more. Okay, and you may not have those funds up front. What I tell people when they first start out, let's prove that you have the business. Let's prove that the business is viable. Let's get some customers. Let's get some clients. If you're a small business, let's be sure that your business is going to last for a while. And it's not necessary for you to immediately go out and file a trademark or a service mark. What's the point if your business is going to fail in the first year? Let's get some clients going. Let's get some customers going, and then consider it. It's worthwhile to pursue it. Don't get me wrong. I'm not saying never register a trademark or a service mark, but let's get your business up and running first before we start worrying about that. Okay. One of the other questions I ask: who are you servicing? Think about a auto mechanic shop. I have one down the street here in Venice, California, that is only servicing customers around these neighborhoods. Does that mechanic care that someone in Alabama is using the same trademark or service mark that he has? I wouldn't think so. How would they even know? Why would they care? And why, for that matter, why would the person in Alabama that's using the same trademark or service mark care that someone in Venice, California is using it? So you might want to look at who you're servicing. If you have a national brand, yeah, of course you want to have a trademark or service mark. But if you're only servicing local customers at farmers markets, does it really matter to you, given the expense? Now, I'm not saying don't ever do it. I'm saying consider your objectives and why you're doing it. Okay? At some point, yeah, you do want to do it. What if a national brand starts to use your trademark or service mark? Absolutely, you want to be protected. No question. They're not likely to do that, but you want to be protected. Now, the steps. First, you have to do a search at tests to the USPTO and at the California trademark site. Okay, this is the California Secretary of State. I've given the link down here at the bottom of the slide. Okay, you search for keywords. And if you want to register multiple words in such and several colors, you'll need to complete an application for each. So now the fees keep adding up, right? There is a way to track your progress on the trademark status site through the USPTO. And if you're doing it in California, then it sets a date when you actually registered. So you might end up filing in California and federal. When I've spoken to intellectual property attorneys, they told me it doesn't make sense just to file in California. You might just file nationally anyway. By the way, there's also global file, and I'm world global patents. It's up to you to decide how you want to move forward. But at some point, yes, you should file a trademark, depending on who you're servicing. Okay, so I have a question regarding the new influx of businesses selling printables online, planners, ebooks, etc. There are two questions. What's the best copyright protection for the business venue? Given the recent ruling that AI developed illustrations placed on a book cannot be copyrighted, yeah, the AI issue is a huge one, and I don't have the answer for that. Okay, my thought is that it's not your words, so it doesn't deserve copyright protection. So I agree with that. What's the best copyright protection for this venue? Again, you just register your copyright with the USPTO. That's all you have to do. You have to determine your application filing basis. You have to specify the reason why you are allowed to register your trademark. It's known as a filing basis. Right? There's multiple filing bases, but the two most common ones are use in commerce versus intent to use. Understand the differences between the two of these. Okay, use in commerce means you are using your trademark or your service mark in selling or transporting your goods out of state, or in providing services to customers who live outside your state. So there's an example here. This came from the USPTO. You might grow wheat in Kansas and sell it to buyers in Massachusetts or Mexico. Or you might provide website design services from your home in Oregon to customers in Georgia and Guam. Okay, you need to provide evidence that you're using in commerce. That means you need to submit a specimen. Specimen is an image or or something that a graphic showing how you used your trademark. You need to provide the date you first used it in commerce and the date you first used it anywhere. That's use in commerce. Intent to use is different. Means you haven't started using the trademark in commerce, but you have an intent to do so within the next 3 or 4 years. Yeah, here's another example. You intend to make and sell jewelry, or appliance like this, make and sell jewelry, but you're just at the point of sourcing materials. You haven't made this jewelry, you're not selling jewelry, you're just figuring out how to get the materials, how to get started, how to register your business, but not going to form an entity, all that stuff, write a business plan. Or you might be currently providing personal training service on local clients in your state. But in the next year, you'll expand the service into a different state, okay? You can apply to register your trademark with intent to use basis. You can apply to register, but you cannot actually register your trademark until you show that you've started using in commerce and you file a proper form. Understand the difference between use in commerce and intent to use, okay? So an intent to use basis does not mean you registered it. You can apply to register, but you actually register once you've actually started using in commerce, and you have to provide the specimen. Lauren, would you please address the question in the chat, in the Q&A, because someone wants to be connected with an SBDC advisor. Thank you. Now, you have to list the goods and services you use, or if you have a bona fide intent to use with a trademark. The USPTO does have pre-approved descriptions of goods and services. It's their ID manual. You can draft your own, but why? Just use their ID manual. So the US Patent and Trademark Office will compare your descriptions to other trademark applications, determine whether or not there's a conflicting trademark, and they'll let you know. You should do a search anyway, by the way. But use identifications that are clear, concise terms that the general public would easily understand, that accurately and completely describe your goods and services. Don't use vague terms. Don't put in miscellaneous service, miscellaneous products, apparel. I mean, that's too broad. It has to be somewhat specific. Here's again, an example from the USPTO. You know, you might use your trademark as a brand for black short sleeve T-shirt. You don't have to identify them as black short sleeve T-shirts. You can list them as T-shirts or shirts or tops as clothing. They're all accurate, okay? But it can't just be miscellaneous clothing or men's clothing. I mean, it has to be a little bit more descriptive than that. There is something called trademark classes, and when you submit your application, you have to identify what class it falls into. It's a way for the USPTO to organize the goods and service using applications and to assess fees, because the fees are based upon the classes. And it helps them search the database of registered and pending trademarks. So all goods and services are classified or organized into broad categories by international agreement. And it's between 1 and 45, that's the number, known as an international class. And goods and services are never in the same class. So like the T-shirt, figure out what class those T-shirts belong to, okay? And this system that they have, the USPTO, has something called T's Plus. And it requires you to pay all your fees up front. And when you fill out the form, it automatically selects the classification of goods and services. And your filing fee is based upon the total number of classes. So if you're going to have apparel in multiple different classes, you're paying more money. If you can't find an ID in the manual that they have, don't use the form. There's another form. So there's multiple different forms that they have. So here's an example. You have a clothing line of golf shirts, dress shirts, and T-shirts. These shirts all fall under the same class. So your fee would be $250 for one class. However, if you also provide custom T-shirt printing services, you have goods in 2 different classes. And it's also be $500. So understand that if you're going to file in one class, that's one fee, but if you're going to file in 3 or 4 different classes, that's more fees. know your classes. That's what I have for today. Next week, I will talk about patents. And although we are not intellectual property attorneys, should you choose to get involved with us, engage with us on one-on-one consulting, we can provide you with various resources and provide you with additional information regarding trademarks, service marks, patents, trade secrets. Protecting your intellectual property is really important. You also need to have a way to monitor infringement. What's the point of going through all of this if you can't monitor it? And there are services that you do that. Now, I will tell you, and I'm just going to the top of this presentation, that there are businesses out there online that will go ahead and file your application for you. I'm going to suggest that you should always go to an attorney for legal matters, because they are best suited to help you figure this stuff out. And when it comes to patents, by the way, a patent attorney must have an engineering degree and a law degree. It's very specialized. So if you're going to go do a patent application, and there's 3 different types of patent applications. There's a utility application, there's a design application, patent application, and actually there's people who want, it's a plant, people who deal with plants. It's a plant application. Do it through an attorney. Don't do it on, and my best advice is do it through an appropriate legal representative, not through an online service, or else you're may end up spending a lot more money in the long run, and it may not be done properly. Okay, so I don't have any more information for this presentation right now. If you have any more questions, please put in the chat room. For those who want to meet with us, we have the Small Biz LA site, and you can go to the Small Biz LA site and register with us. So it's the smallbizla.org. Any other questions for me? If not, I'll wish everybody a good day. For those who want access to this, you can write to Lauren, and we also have a YouTube site where we post these. I've put our smallbizla.org website into the chat room. Well, I'm going to thank you everybody for joining us, and hopefully we'll see you next week. Bye now.